It's really lovely to be here. I'm only sad that I'm not with you in person, since Toronto's one of my favorite cities in the world. But hopefully this will serve as kind of an entry point to more collaborations in the future. So we're going to talk to you today about a paper that Angela and I have been working on for a long time. It started when Angela was still a student with us in law school. Now she is an incredibly seasoned graduate and has been doing wonderful work as a law clerk for some really extraordinary judges. But this is a project that started with really trying to interrogate how NFTs changed the framework of digital art and also how NFTs changed the framework of copyright law. And as we got deeper into the sort of world of NFTs and studying how the intersection of intellectual property, creativity, was unfolding, we also started to recognize kind of a larger phenomenon that was happening with respect to contract law. And we started seeing kind of this pattern that was unfolding with NFTs that we thought was really worth interrogating, and that is the pattern of like creating sort of a new disruptive kind of unique technology that is mapping very uncomfortably onto intellectual property principles, challenging a lot of intellectual property principles. And that kind of indecision or that kind of destabilization kind of paves the way for the entry of contract law. And so we wanted to interrogate kind of that formation um, in terms of sort of the sort of uncontrollable technology or technology that challenges deep presumptions, transferring into a technology that is increasingly being governed by contract law. So we started kind of mapping this out along the NFT realm. And then as we were mapping it out along the NFT realm, we started to realize that actually, in many ways, kind of the same sort of thing was unfolding with respect to generative AI. So now the paper kind of then morphed into a greater sort of comparison of the technologies, the impact, and the difficulties of governing these two worlds, but also interrogating the conflict and the contrast between NFTs and Gen AI. And so this paper descriptively focuses on the difference between them, but also more normatively focuses on questions of how the law should exercise leadership in terms of governing these two realms. So that sort of, I want to just kind of set the tone for the paper. And now, let me tell you a little bit about sort of where we see things going. Angela, do you want to go to the first slide? Okay, great. So this is the agenda that we're going to be talking about today. We'll start off by talking about NFTs, and I will set the stage with some of the copyright issues with respect to NFTs. And then we will turn things over to Angela, who's going to talk about Gen AI. And then we'll wrap up by talking a little bit about sort of the future of digital art as it connects to these two mediums. So let's start with a quote that I generally think is a really helpful quote. So I'm going to talk generally about NFTs, and then we'll turn things over to discussing sort of some of the implications of how law governs NFTs. So years ago, Lawrence Lessig, who is in many ways kind of a trailblazer for thinking about intellectual property and cyber law, said something really profound. And he warned society of the dangers of something called a permission culture and and used the term pay per use society. And this idea was that he was very fearful of this world where we might require licenses in order to create. And so this really sets the stage for what we're thinking about, which is with the rise of licensing and contractual restrictions in the digital creative marketplace, we're seeing some of those predictions coming to pass. And so the unsettled law regarding digital art, we think, is a really important prison in order to examine its broader future. So while many scholars kind of question the novelty of digital art within the governing realm of IP, we argue that irrespective of those questions, the real danger behind digital art actually lies in the rise of contractual restrictions that can be built into their design, carrying the potential to control downstream forms of creativity. And so in this article, we basically argue that these privately ordered worlds risk producing a world where digital creativity is conformed and thus transformed not by intellectual property principles, but actually by contractual control. And the rise, we think, of digital art in this world, particularly with respect to Gen AI, forces us to contemplate how conventional legal paradigms, particularly contract, creativity, and intellectual property, carry both limits and possibilities within this world. And we think that copyright and trademark law will be increasingly asked to respond to these shifts. And it has a real, we're sort of at a crossroads where it can either expand, loosening its grip over creativity and enabling decentralized forms of creativity, or it can contract, and we mean this in a literal sense, resurfacing old tensions about openness, access, and unlicensed use. And we think that this is particularly important because as digital creativity becomes more derivative, putting such creativity in digital hands, we think will runs the risk of actually contracting the pool of available raw materials from which others draw upon. And we think that this runs the risk of shrinking the public domain, rendering culture into something that is accessible only by digital key. So not only does the rapid expansion of the digital art market, particularly by way of Gen AI and NFTs, raise complex issues of intellectual property infringement, but it also raises complicated issues of contractual control over creativity. And so we think that digital art has really emerged at sort of the perfect intersection of three overlapping schemes: creativity, contract law, and property. And they're sort of intimately related to each other in the sense that an expansion of one, say creativity, carries dramatic costs for the other two realms, property and contract. And an expansion of contract law has dramatic costs for creativity and property. And an expansion of property has equally dramatic costs in the other direction. And so we try to sort of map out each of these possibilities loosely tied to NFTs and Gen AI. And so they really force us to kind of contemplate how NFTs and Gen AI are emerging within a world of increasing governance by private ordering. And the unsettled law is really a great opportunity for us to explore the broader future of digital creativity. So, how do we think about Gen AI and NFTs? Well, on one level, we think that they represent kind of inverse philosophies regarding digital culture. AI celebrates abundance, decentralization, unrestricted extraction, generation of infinite possibilities for creation. And NFTs, as a structure, as we'll talk about shortly, tend to impose scarcity, ownership, and contractual control onto the inherently non-rivalrous nature of digital content. So Gen AI produces creators, but not necessarily owners. And NFTs produce owners, but not necessarily creators. And so in each realm, we worry about the advent of contractual control. Um, and so, as I said at the beginning, we worry about the sort of rise of a permission culture, a pay-per-use society, from a free culture that allows content to be circulated more freely. And so while many scholars rightfully question the novelty of digital art in the realm of IP, we think that the danger of the thing that digital art does is that it raises the specter of private ordering. And the specter of private ordering has the potential of displacing kind of guidelines of fair use and other limitations. And that these effects we think are going to be really significant. We're not talking about like in the next year or so, we're talking 10 years from now, right? Whereas contractual provisions are increasingly allowed to kind of govern specters of digital art, it runs the risk of foreclosing derivative streams of creativity that are not kind of authorized beforehand. And we worry about how this will shrink the public domain, rendering culture accessible only by a kind of digital key. And that this will actually create more power dynamics and power inequalities as a result. And so this transformation, we think, is just starting to unfold. And I think that eventually it will leave the future of digital art in question. And it is starting to unfold with the advent of NFTs. So if we think about Gen AI and NFTs, they're kind of two sides of the same coin. If Gen AI disrupts traditional authorship by expanding the pool of who can create, NFTs actually try to reassert control by defining clear boundaries of ownership. But while Gen AI kind of advocates, or at least is premised on this idea of sort of unfettered algorithmic creation, NFTs actually restore scarcity, and they restore ideas of control through these sort of immutable tokenized records on the blockchain. And so we think that this is a particularly interesting moment for us to study the composition or the contrast between these two frames. So just as conceptual art, in the 1960s and 70s, disrupted assumptions about what art could be and become, we think that Gen AI and NFTs actually do a very similar kind of thing. They challenge what ownership and authenticity and originality looks like in the digital age. And so this kind of instability that comes out of using these old established frameworks onto these new realms creates a kind of instability that we think is going to pervasively impact the marketplace of digital art. So gallerists and museums and collectors have long focused on the idea of looking at market value through the lens of creating works that have essentially been created in the absence of permission. Many works have been created as the result of sort of expansive claims of fair use. And we wonder about whether or not that sort of expansiveness will be able to be sustained in this new advent of digital art. So rather than authenticity functioning as kind of a guarantee in the art world, we think that authenticity is increasingly going to be sort of occupying the battleground for creativity. And so where do we see this pattern starting? Well, we see this pattern starting with respect to NFTs. So experts have speculated kind of numerous implications for the NFT economy. Some at the advent of NFTs predicted its ability to democratize the art world by directly connecting artists and patrons, by empowering artists to have greater control beyond copyright. And we'll talk about how that happens. But others take a more darker view, and they hold that kind of NFTs are more linked to the kind of rise and fall of the crypto marketplace. They are a harbinger of future kinds of conflicts to come. Now, we sort of have been very deeply convinced by the trailblazing work of Amy Adler, who has written on NFTs and who writes that the idea of artificial authenticity actually pervades the creation of NFTs, that the essence of the art is kind of is represented by something other than the art itself. And the term NFT is often conflated with both the token and the underlying digital artwork, but the two are actually very distinct. So NFTs are actually unique digital tokens that represent something of value. Most often they represent a piece of art, but importantly, they actually do not comprise the art itself. So a district court judge, Jed Rakoff, described the NFT as, quote, a sort of digital deed representing ownership in a physical or digital asset. And blockchain is kind of essential for making this happen. And the blockchain is kind of a database that exists across computer networks and has no sort of central location. And its name, NFT, comes from the function, or the blockchain's name comes from the function of assembling and stringing together information in kind of blocks of code data. And some of that code data encompasses links to NFTs. And each block and code on the blockchain is immutable. So once information is stored on the blockchain, it becomes largely permanent and immutable. And so each of these processes of creating sort of NFTs actually rely on these pre-existing protocols. But in many ways, because of the direct transfer of information from the creator to the owner to the buyer, there's really no sort of gatekeeper economy when it comes to selling or marketing NFTs. There are some sort of platforms that sell NFTs, but many people feel that NFTs really decentralize the art market because it basically means that there are no gallery owners, middle players sort of in the field that are in the role of curating as aggressively as we see in the real market, in the real space market of art. The steps to sell an NFT are incredibly decentralized. They are facilitated by a fusion of contractual control and technology. So how do you create an NFT? Well, you create an NFT by making a digital work and then converting it into a digital file format. Then you select a blockchain platform that will house all of the records of the digital artwork, like Ethereum. Then you create a digital wallet that connects to the Ethereum blockchain and contains all of the sort of artist assets that can be bought or sold for Ethereum or whatever kind of cryptocurrency you are dealing with. And then the artist can actually upload the digital work of art to their wallet and then link it to an online NFT marketplace like Rarible or OpenSea. These are very loosely curated kind of platforms, and they can auction it or they can sell it for a fixed price. Angela, could we go to the next slide if you don't mind? Okay, now the earliest NFTs were really interesting because they used their freedom of contract in order to create very broad terms, broad contractual terms to widely embrace downstream creativity. And this is really important because NFTs, because they are sort of like digital deeds, they do not automatically transfer copyright. Buyers only get the token to the artwork. They do not get the underlying IP rights, and the NFT creator actually retains copyright ownership unless it's explicitly assigned or licensed. And so early NFT creators actually used a general use license agreement that granted buyers limited, worldwide, non-exclusive, non-transferable, and royalty-free licenses to use, copy, and display the underlying asset in one's token wallet for personal, non-commercial use or resale. And so what's interesting here is that this kind of dynamic actually shows us something really important. It shows us something that, is often referred to in the sort of internet law context, the idea that code is law, right? And this is a subtle and sort of sometimes less subtle emergence of terms and conditions that can actually defy not only existing statutory limitations, but they can also defy kind of the precepts of common sense. Now, how does this happen? It's because NFTs have a tremendous amount of control. They can execute contracts and grant licenses to use their works, just like artists do in the traditional art world, but they can actually go one step further than the provisions of copyright. So an artist could license their distinct drawings of Santa Claus, for example, to Hallmark, granting them the right to use the image in holiday wrapping paper, paper plates, wall art, stickers, right? But more importantly, they can also limit the uses of work. So digital copyright holders in particular can kind of extend prohibitions on uses of their work. And so instead of being governed by traditional trademark and copyright protections, they can be governed by something else, which is contract law. And so upon purchase, smart contracts can kind of enter into the picture. And these are digital contracts that are embedded into NFT's code on the blockchain. These are often self-executing, and they operate to transfer authorized payment from the owner to the buyer, but they can also do much more than that, right? They can automate royalty payments, resale restrictions, usage permissions. And these contracts, we think, can enable an unprecedented level of control over downstream works. They can produce a world where only downstream or authorized creativity becomes permitted because the smart contract can be so powerful. And so it's important to sort of think critically about the role of smart contracts. And part of that is because they can displace, as many scholars have written about, they can displace the traditional architecture of law. They can operate essentially in sort of legal free fall without a governing legal framework. And so the Russian Prime Minister, Dmitry Medvedev, actually describes smart contracts this way, as a new challenge to legal regulation. And he observed systems creating such contracts live by their own rules beyond the boundaries of law. And so we see a real risk of this kind of unfolding because the constellations of digital rights and privileges that an NFT creator maintains is essentially much broader than that constellation of rights and privileges that you would get normally through the use of copyright. So one example of this involves the right of distribution. So one of the most desirable rights enjoyed by a traditional copyright owner involves the right to sell and distribute copies of an original work. But if an NFT purchaser wanted to create further downstream projects, they have to actually procure this underlying distributive right to copy and distribute the underlying work. And so in most cases, the advent of smart contracts means that individuals are sort of given a take it or leave it kind of option. And once it's encrypted onto the blockchain, it cannot be created. So this is really important because early sort of NFT communities actually utilize these contractual terms for great levels of freedom, but newer kind of NFT communities have kind of foreclosed that sort of freedom to create and exercised a much greater level of control over their NFTs. And they do this in part because of the ability of a smart contract to kind of govern an NFT, and also dispensing different kinds of recognitions of things like authenticity, things like fair use, things that normally might be within the domain of copyright law can now be restricted within the domain of smart contracts. And so since code, as opposed to statute or common law, can now grant kind of more exclusive intellectual property rights to NFT owners via smart contracts, we argue that this creates an even more powerful form of intellectual property. And so this transition that we're talking about, the creation of a new technology that is uncomfortably governed by law, results in a world where intellectual property governance has largely been kind of subsumed and overshadowed by the advent of contractual control. And we think that this chain of events is actually not just happening in the context of NFTs, it's also happening in the context of Gen AI. And now I will pass things over to my co-author who's going to talk about generative AI. Thanks so much.
Thanks, Professor Katyal. That was really excellent. Okay, so I'm gonna now just overview what generative AI is, and then we'll come back to a lot of these concepts that Professor Katyal talked about that we're seeing with private ordering in NFTs, and they're all going to come back in generative AI through our discussion of it as well. So I'm sure a lot of you are probably very well aware of what it is at this point, and you all use it in your day-to-day. But just a quick overview. Generative AI, we're calling it Gen AI for short. It refers to systems that create new content, so images, music, code, all sorts of creative outputs, and they're built on machine learning models that are trained on large data sets. They mainly generate novel outputs. They don't just do a one-to-one, replicate what you've put in, but they create something basically like new. That's kind of the idea. And you can read our paper if you want to go into all the technical details of how these LLMs and these transformers work and how they use the data that they collect to then generate this new content. But I won't go into that now. And the idea with a lot of these LLMs is to resemble a human creativity, human thought, human ingenuity. And so it's very, very human-like creations. So we see that with obviously ChatGPT is probably the most commonly used example. Anthropic's Claude is also very similar. Uh, Grok and Sora are more newer kind of image-based creative outputs that we're seeing in the LLM space. And a big important part of generative AI that we see to digital art is it just rapidly incentivizes the creation of digital art, right? Because the barriers to it are so much lower. Anybody can just get on their computer or phone or use this platform, most of which are free, and you just put in an input, you put in your ideas, and you're able to almost instantaneously get a creative human-like output. So it lowers that barrier. It makes everybody who has access to the internet essentially an artist or creator, somebody um, who can then potentially be holders and owners of their own digital art and creations. So, some of the legal issues in generative AI, we're going to talk about. Our paper specifically talks about the copyright issues, and there are many. There are probably too many to go over in depth, but the main two that we see are ownership and then the fair use issue. So, to just go over the ownership issue, which I think is the more simpler of the two, the question that has arisen with generative AI and copyright is when you have a generative AI model that creates work, who owns the copyright? Does the actual human who inputted the prompt of, create an image of so and XYZ, do they own the copyright, or is it possible for the AI model to own the copyright? Does the company who created the model own it? Who owns it, right? So that's a big question that's come up, although historically and up to this point, the Copyright Office has been very consistent with their approach to answering this question. They follow the human authorship requirement. So in the Copyright Act, it states that the only way that the only way to own a copyright is that you have to, well, not the only way, but you have to be a human that creates art to be able to own that art. So this is my favorite example of the human authorship requirement. As you can see, this picture of a monkey here on the right is from this Ninth Circuit case in 2018 called uh, Naruto v. Slater. And it involved this professional photographer who went to Indonesia, and he was taking pictures of monkeys in the forest. He put his camera down, and a monkey named Naruto came up and stole the camera and actually took a photo of himself. He took a selfie, and that is the selfie he took. And the photographer later published a book of all of these photos of the monkeys that he took, including this photo. And an animal rights organization, PETA, actually sued the photographer and argued that the monkey Naruto should have the copyright to his selfie because he's the one who took it. The Copyright Office, or basically the Ninth Circuit and the Copyright Office, they consistently again applied the human authorship requirement to hold that because Naruto is not a human, he could not have standing under the Copyright Act to own the copyrights to his selfie. So that concept you can apply to generative AI. The Copyright Office has done so very consistently. Um, Generative AI models, the model companies, they do not own the copyright to works only if the production of the art is human based, can anybody own the copyright. And so there have been a bunch of cases. There have been a handful of cases recently, not law cases, but applications to the Copyright Office, where we see artists who have had, say, there's one where the artist made a comic book and all of the art was created by AI, but the narrative, the story, the compilation of the images was they argued, or they wrote very clearly in their copyright application, that it was done that the compilation and selection was all done by the artist themselves and not the AI models. And so the Copyright Office has been very willing to grant copyrights in the selection and arrangement of AI generated works, so long as those selection and arrangement are done in a sufficiently creative way that is reflective of like the human creativity and ideas. So that's the first issue that we see that's come up quite often in generative AI copyright. The next one, and this is the one that we talk about the most in our paper, is the question of when is a generative AI model infringing versus when is it creating outputs that can be considered fair use under the Copyright Act's fair use doctrine. So we all know that generative AI systems are trained on enormous data sets, right? Like millions, billions of trillions of data. And a large number of that data is copyrighted works, right? Whether taken from publishers or other individual authors that own copyrights. And so we also know that the Copyright Act under Section 106 gives copyright holders the exclusive rights to reproducing the works, creating derivative works, distributing the works, among many other rights. And these generative AI models often produce outputs that really often maybe they're not identical one-to-one replications, but they are very much similar and resemble and replicate elements of the copyrighted works, so that they probably likely fall under Section 106 of the Copyright Act, where there become tensions between like whether these generative AI models are reproducing works, creating derivative works, or unfairly distributing copyrighted works. So we're seeing a large number of lawsuits in which the generative AI companies have to argue that the models that are creating these outputs are sufficiently transformative under the fair use doctrine, and that they often serve a different like core purpose than the original works. And we'll get into a couple examples. And on the other end of these cases, the plaintiffs, many of which own the copyrights or are the publishers, argue that these generative AI models are creating outputs that are not fair use under the fair use doctrine. They aren't transformative and they serve the same purpose, and they also overlap with the market for the original copyrighted works. So we're still really, really early into resolving this litigation. And so I want to just actually take a step back really quickly and talk about a core fair use case that has this framework for how to apply fair use doctrine to new technologies and new creative outputs on digital outputs that courts are going to adopt as a framework for thinking about how to apply the fair use doctrine in generative AI. So, and you may already know about this case, but this is a very famous case from Google Books, Authors Guild versus Google in 2015. Google Books came out as this technology to basically digitize the world's books, right? And so they digitized book collections of major libraries, and over 20 million books were digitized without permission of a lot of these publishers. So, what was different though was that these books were not just completely scanned in their entirety and then published online for anybody to access for free. The concept that Google was trying to do here was actually just to create an indexing system so that you could search for any book in the world, not that you could read it. So you could see all of the titles, the publishers, the all of the information about the book, and then you could maybe see the first couple pages. And I'm sure many of you have used Google Books and have experienced trying to like find read through a book, but being stopped because it won't let you read the whole book. But nevertheless, the Authors Guild, which is owned the copyrights to many of these books that Google had uploaded, sued Google saying that this was infringing on their copyrights for these books. The Second Circuit ultimately held that Google Books's indexing function, the search function, was sufficiently transformative under the fair use doctrine because it made information about these books available, but it didn't actually provide a complete one-to-one substitute for the copyrighted parts of this book. So you can see like the purpose of using Google Books to find a book and maybe get a general sense of the information about it is very serves a very different purpose than actually reading the entire book, perhaps for research or enjoyment in itself. So this fundamental like question about transformative use and also a question of the market overlap between the original copyrighted works and um, this new function like software platform. This is like a core framework that courts are using in generative AI cases today. So I'm going to explain or summarize to you basically the three major cases right now. And of course, this is going to change because litigation is just, there's so much of it and it's happening so fast right now. But as of today, there are three federal district court cases that have actually spoken on the question of fair use and whether generative AI models are creating outputs that are sufficiently fair use under the doctrine. And so that's Thomson Reuters versus Ross Intelligence, Bartz versus Anthropic, and Cadre versus Meta Platforms. So in Thomson Reuters versus Ross Intelligence, that was a case, or that is a case where Ross Intelligence they're a startup, an AI startup that is trying to compete with Thomson Reuters, who creates the Westlaw product for legal researchers. So Ross Intelligence was trying to create a competing AI-based product for legal research. And they asked Thomson Reuters for permission to use the Westlaw head notes, which are a key feature of Westlaw is summarizing cases in core concepts and core legal issues that helps legal researchers identify cases and like subject matter and legal issues and cases in a very like organized, systematic way. So that's very specific to Westlaw. That's a core product that they offer. And Thomson Reuters said, no, you can't use our head notes. So Ross Intelligence went ahead and used them anyways, and they took the head notes and they inputted them as data into the chat GPT, into their, sorry, not chat GPT, into their own AI legal research model to create their own set of like similar set of head notes and their own legal research database. And the a judge in the District of Delaware held that this was not a fair use of Westlaw head notes because the purpose of the using the Westlaw head notes was to create basically a market substitute for Westlaw, right? So Ross Intelligence wanted to create a direct competitor, and so they used the head notes to create their own legal research tool that also has its own way of categorizing and systematically like organizing legal cases. So that's an example where using data, copyrighted data for a model is not transformative, but notice how fact specific and like how directly specific it is to the purpose of the model and what kind of market it was trying to reach in its production, in the production of its content. The second one is Bartz v. Anthropic. And so this was a case in the Northern District of California. Bartz is one of three authors. They sued Anthropic for using their books in Anthropic's model and chat in Anthropic's generative AI model. And the main issue there was actually that the authors knew that Anthropic had illegally downloaded all of their works and then put them in as mod into the model. And so what ended up happening was Judge Alsup in the Northern District of California was really deciding on that specific issue of whether it was unlawful to illegally download the content, as opposed to whether the models were creating um, content that was infringing on the author's books. However, Judge Alsup still sort of opined on the transformative issue because it could have, it could have gone to court, it could have gone to trial, and he said that the Anthropic's model was exceedingly transformative, among the most transformative technologies that we'll see in our lifetime. And he did think that Anthropic's use of these copyrighted books was fair use. Although this was in dicta, and this was just him speculating on, were the case to go to trial or were he to decide the case before trial. That's probably what he would hold. But that case actually ended up settling. Um, and so that issue of transformativeness uh, it was not actually ruled on. Cadre v. Meta Platforms, the third and final case, is very similarly along the same lines as Bart's v. Anthropic, where I think this was over a dozen authors in this case sued Meta for using their copyrighted books in Meta's generative AI training models. And Judge Chabria, very similarly to Judge Alsup, also opined in dicta, so did not decide the issue, but found um, or opined that the use of the copyrighted books to train the model was highly transformative. And he specifically said, as to the purpose question in fair use, that that the models training the model based on these books serves a very different purpose than reading the books themselves. So this is kind of, a similar analysis as the Second Circuit's analysis in Google Books. Um, and Judge Chabria also did note that there could be an argument in favor of the plaintiffs if they were able to prove that there was like a market harm to their copyrighted books by people, maybe going onto Meta's generative AI platform and summarizing the books and reading the summaries, as opposed to, actually buying the books and reading the full books in their entirety. However, the plaintiffs did not make that argument. Judge Chabria just kind of like said that they should have made that argument and their case would have been stronger if they had. But that he made sure to really limit his ruling um, in in not definitively saying that the Meta's generative AI models were sufficiently transformative. Um, so this is a very chaotic image that's tracking all of the cases that are happening in the copyright space for generative AI models right now against generative AI companies. There's over 51 cases across the country, and I'm not, I'm basically just showing you this to illustrate just how like ripe for a decision on the fair use question that we are at this state in the world and in the litigation of generative AI companies. Um, and so the main takeaways here, we see that in terms of answering this question, are generative AI models uh, infringing or are they fair use? It's really seems to be a case by case determination. It seems to be really highly fact specific to like what the models are doing, who's using the outputs of the models, and what the original copyrighted content is. The judges, especially Judge Alsup and Judge Chabria, are really making sure to limit their holdings and not make broader statements um, on whether these models are fair use. It's because of the fact-specific nature of all of these decisions, we may not see any binding precedent on this question. Although one of the cases did get appealed to the Third Circuit. So, we might see something come out of the Third Circuit, but if it does, it would probably be in 2026 or even later than that. So earliest is going to be next year. And then the really significant outcome of all of these cases is that AI companies realize that this question presents really, really high litigation risk and uncertainty for their ability to operate their models lawfully. And this is causing them to make shifts in their strategy. And they're, instead of pursuing litigation and really doubling down on the fair use defense, they're switching over to private ordering, which is very similar to, the type of private ordering that we saw with NFTs and the way that these finding private resolution, contractual resolution as a way to avoid uncertainties in litigation. Um, so one example, Bart's v. Anthropic settled for $1.5 billion, and they did not resolve that fair use question. They decided to just settle around it. Anthropic, as part of this agreement, deleted all of the pirated data and also was able to say as part of its agreement that it didn't use it in any of its models. We're also seeing licensing deals, multi-million-dollar licensing deals among a lot of these generative AI model developing companies. Microsoft signed a deal with Taylor and Francis and HarperCollins. Those are two major, one's an academic publisher, one's a major just like academic and literary publisher. Universal and Warner Music are making many deals with startups that are in the music, AI music space. Google has made a deal with Reddit to license their material for their AI models. And we also see a lot of other digital publishers like Yelp and Reuters, and then also even print publishers like Condé Nast, also licensing their content to generative AI to be used in generative AI models. All of this is happening even though no court has required that these generative AI model company creating companies need to do so. No court has said that they need to make these licensing agreements, and yet all of them are like really just jumping very quickly to do so before there can be like a risk of a negative outcome in litigation. One of the unintended outcomes of this trend that we're seeing is actually that while the publishers are making these really profitable licensing agreements with the AI companies, many of the individual authors who make up the base of the publisher's works, they may be kind of like getting the short end of the stick of these private ordering agreements, right? They aren't able to really have a say in whether or not their works are going to be used in these models. They may not even get any like cut of the deals, right? They might not get a cut of the profits of the settlement agreements or the licensing agreements. And so we have seen a couple cases where some authors are just feeling very um, disincentivized and like very unmotivated by this private ordering system. That's kind of just not considering the actual creator's best interests. So this is all part of this greater trend that we're seeing of permission culture that Lawrence Lessig kind of warned of like in the 90s. Every creative act that's happening today requires prior authorization through a licensing agreement that it's not even legally required at this point. This is undermining the whole doctrine of fair use because with fair use, you can have really transformative, like incentive to create transformative works that are not authorized, right? You can go ahead and just make a satire if you want to. You can go ahead and make a derivative work if you want to, as long as it's sufficiently transformative. But right now, we're seeing the fair use doctrines like power is really not being fully wielded to its full potential. And this is resulting in what once was like an open creative ecosystem when generative AI first came out, and we saw tons of, it lowered the barriers to creativity, tons of people were utilizing it to make art. And now it's going to be like a system of where creativity is pre-authorized and pre-approved. Um, just some other examples of the private ordering mechanisms that we're seeing. One specific one is that you can actually, and this is in line with the NFT smart contract like trend that we saw in NFTs, you can actually auto embed like copyright enforcing mechanisms into the generative AI systems. So I think we've maybe if you've used generative AI, you might have come across this. Um, OpenAI, for example, you cannot create outputs that might infringe on particular copyrights. So for example, if you try to get generative AI or Dolly to, you know, make me an image of Batman eating a hamburger, like it's going to stop you from making that output. And it will say, we can't infringe on the Batman copyrights, and so we can't make this image. So that's an auto enforcement mechanism where the law is in the code, right? These systems are actually encoded with following copyright law. But the problem with this is that we think that these auto enforcement mechanisms are over exclusive, right? Because they're just excluding every possible output that might have these copyrights, but it doesn't account for the purpose. It doesn't account for lawful uses like educational or research purposes or satire. And those are all fair uses, right? Under the fair use doctrine, I should be able to make an image of Batman um, eating a hamburger. If it's not, I'm not going to go out and sell it. I just want to see it for my own personal purposes, right? And so we're seeing an over exclusivity through these smart contract, these law and code systems that are being embedded into generative AI models. And this all contributes to this overarching trend that we're seeing where contract law is effectively overriding copyright statutory protections and copyright systems that should incentivize and like foster and protect authors from making highly creative works. So yeah, this is just another kind of summary of what's happening. So just to recap, these private contracts and like auto enforcement mechanisms are causing this um, really dangerous shift into a private ordering system instead of trusting the law, to the public law system to be protecting these copyright holders, and incentivizing creation. And then also, a lot of these individual creators and copyright holders are kind of beholden to these private agreements that between AI companies that don't consider their own individual interests or rights. Um, Questions of authorship, infringement, and originality are decided by code instead of by courts. These courts, and partly maybe that is because these courts are not like willing to really put their foot down on this issue and they're doing making dicta, but regardless of like what the purpose or intention is in the courts for not definitively deciding the fair use question, it's really blurring like the accountability of what's happening with fair use, and it's transforming copyright into a system of private governance, private ordering, as we've discussed, and creative rights are being encoded and sold in these licensing agreements and settlements rather than protected through the Copyright Act and legislated through, potentially like amending the Copyright Act. So this is really ultimately undermining copyright law as we see it, as it's been, for the past um, many decades. And these questions of authorship, fair use, public access, and use of art are really just being um, just really destabilized. So
Uh,
yeah,
oh, and do you want me to take it back down?
yeah,
Okay, okay,
exactly. I was
awesome.
going to turn
All
it
right,
over to you.
so let's just wrap up because I'm really excited to hear people's suggestions and thoughts and questions about what we've just presented. But I think the general sort of upshot of what we're trying to point out is that all of this eventually can impact the public domain, right? The more rights holders can contractually restrict how their work is transformed over time, the more they can kind of undermine the very legal doctrines that nurture and protect a kind of vibrant public domain. And so, in effect, by embedding restrictive licensing provisions into the inputs of generative AI systems, we actually do risk a future in which one might actually need permission to be creative. And that is something I think that the paper really tries to grapple with. So, thank you so much. For sticking with us during our chat. I'd love to hear folks' thoughts, comments, questions. Let me just ask Anna, how much time approximately do we have for questions?
We'll probably have, so it's not 1:29 right now. We have about until 1:55 perhaps, or close to 2 for
Okay,
Q&A. So
great, great.
yeah, okay. Thank you so much, Professor Katyal. Thank you so much, Angela. We're now moving on to our discussion period. So please, people who have questions, please use the raised hand function so I can see you and then call on you. Um, uh, is anyone? Oh, sorry. Am I seeing somebody? Okay, maybe while people are collecting their thoughts, maybe I can start by I can exercise my moderator privilege. So it seems to me from the talk, it seems like you're basically saying that what I understand to be saying is that because of the a lot of these legal uncertainty, is it more that these private ordering mechanisms are coming about because of the legal uncertainty, or is it the other way around? Or like they would have gotten to these private ordering mechanisms anyway, even without this legal uncertainty, right? Because even like the concept of fair use and how it applies to like trying to constitute the the training data, is that really analogous to like the books that were scanned for the Google Books case? I mean, all of those are unsettled questions at this point, and so yeah, I just wanted to hear your thoughts if you think that the private is stepping in because the public, we don't know what the system is like right now, or would it have happened anyway? I mean, that could be my first question, but I have others.
Yeah, I love this question. Thank you so much, Anna. I think that I'd also be really interested in hearing Angela's thoughts to this. I will just say that obviously I think contractual provisions are always going to be present in any kind of a transaction. I think that that's a natural kind of extension of what it means to contract around IP. I think the worry, though, is that there's something about the way that the law is evolving that has empowered um, intellectual property owners and creators to feel like they, need to take further steps, either to avoid being framed as empowering or aiding and abetting infringement, or because they do want to control the acts of the authors and the creators that come afterwards. And so I think it's kind of a mixture of things. I think you're right to say that the contracts would have existed no matter what. I think the extent to which we're seeing the restrictions, I think, open up very little possibility for kind of unlicensed use. What do you think, Angela?
Yeah, I think if we look at when generative AI models first were created and first went onto the market, the trend was to ask for forgiveness and not for permission. So a lot of these companies like OpenAI was scraping, right, data scraping all of these websites and
Mm.
Reddit, for example, right? And they weren't asking for permission. They were just going out and doing it. And then, like Professor Katya said, the law right now is giving authors and creators and copyright holders, it's empowering them to go after their rights and what kinds of like profit is rightfully owed to them, right? And so then we saw people utilizing their rights more to try to fight these big companies from taking all of this data without their permission. And then as a result, we're seeing this trend where now the companies are kind of backing down and starting to ask more for permission instead of for forgiveness. So it's kind of just been like a shape-shifting trend. But I definitely think, like, to the credit of a lot of these copyright holders, they are, yeah, they're feeling empowered, and it's kind of like exciting to see them use their copyright laws and protections in their favor against, like, kind of like chaos, right?
Oh,
Yeah.
but like, sorry, just one follow up. But like the permission at this point, if you see it as like a dialogue, the permission now comes in the form of these licensing agreements. But as you say, like it's really between the big publishers, for example, and the companies, not necessarily if you're an ordinary person and you're just an ordinary author. Um, you might not consent to what your publisher is doing or something along those lines. And so I guess I'm just like, yeah, I'm just skeptical that this would be, I mean, maybe it is a step in the right direction, but in terms of fostering creativity, uh, like for the average creator, then it might not be, definitely, there's still a long way to go to get to that desired outcome.
Yeah, I totally agree with you, Anna. I mean, I do think that the issues of consolidation and the rise of collective licensing, which I think was at the heart of your question, I think is going to
Yeah.
kind of change the paradigm somewhat. So we'll have to see what happens.
Okay. Yeah, Avery. You.
Hi. Is my
Hi.
microphone working? Yeah. Okay. Yes. Okay. Great. Thank you so much for such an interesting talk. I wanted to ask, uh, I think, two things. So first of all, I'm wondering if you want to comment on the position of someone like Benjamin Sobel, who thinks that the problem of market substitution hasn't been fully resolved with respect to, expressive machine learning, and that maybe there is still hope. I mean, I took away from the talk that a lot of these cases are being settled rather than brought to any kind of judgment, perhaps for exactly that reason, because as you suggested, it might in fact constitute massive market substitution. Then I guess the second part of the question, this is more like a speculation, right? As I was following the different settlements and how they relate to publishers who previously had kind of through a contract with authors purchased copyright, and the authors undergo that sort of shifting of IP so that the publishers will distribute their works. So that's why they do it, right? But now I'm kind of thinking, what's the future for authors who, why would they even need the publishers at this point, right? Maybe self-publishing is actually the way this will go ultimately, in this perhaps permission culture around, if you know you can get $5,000 for your book rather than Oxford University Press getting $5,000 for your book, why do you need Oxford University Press at all? So I guess that's more the speculative, like where do you think the industry is going to go? And then also if you had a comment on possible hope around market substitution in the future.
Yeah, great questions. Angela, do you want to take a first crack and then I'll jump in?
Yeah, sure. Market substitute. Yeah, I think they're both like really good questions. I just think that the market substitution issue and whether these generative AI models are creating outputs that like genuinely can substitute for the markets of the original outputs, it's just such a gray area. It's such a gray area, right? Like you can have a really, really clear-cut case like Thomson Reuters re Ross Intelligence, where that one it's very clear. It's just Ross Intelligence even like kind of admitted that they were creating a direct market competitor to Westlaw. And so there it's really clear cut that there's direct market challenge to when Ross Intelligence is making its generative AI model. But I feel like in almost every other case, it's not clear. And maybe that's why in Meta, Meta has great lawyers. Why didn't Meta make that argument in their case with Judge Chabria? I think it's just, yeah, I don't know. It might just be too early to tell. Like maybe we need to see more cases where they actually do try to make that argument and come up with ways that the GPT model, that the generative AI models are creating outputs that are substituting. Maybe we need to actually just see those markets like come to fruition because right now those haven't really made it yet. So yeah, that's what I would say on the market substitution It's like, yeah, it's just an interesting gray area that I don't know if there's quite like an answer to it yet. Any
Um,
thoughts, Professor?
yeah, no, I mean, I totally agree with you, Angela. I would say I can also respond to the second one. I think that at this point in time, there's still, because there's so much content being generated and so much of it is kind of secondary, it's really hard to kind of parse whether something is a raw material or whether something is the subject of reuse. Um, so I think excuse me, for the time being, I still think that platforms like major presses and publishers will still have a really important curatorial role, right? In sort of figuring out kind of what texts, uh, should be sort of brought up to a larger constituent. I still think that there's going to be a lot of real space content in the future. But I do think that as time goes on and as more and more people rely on AI to create, we may be in a different um, we may be in a different world where it's so difficult to distinguish the difference between something that is synthetic versus something that is human created. And I do think that that is going to have a lot of ramifications for presses. Yeah.
Okay, great. Thank you. Barry?
Hi, everyone. Decided to go on camera and unmute myself for a change. I normally don't do that. But hi, first off, I just really wanted to mention how much I really enjoyed the presentation. I work at an AI company, but my experience with generative AI was just lacking. So I actually learned a lot from your presentation. But I had a question for you. So there was a recent case handed down by the UK High Court between Stability AI and Getty Images, and largely Getty Images lost. They were claiming that Stability AI used LLMs that were trained on copyrighted material. The UK High Court, in a short summary, basically said, well, you can't prove damages and you can't really pinpoint which images were used in the training. So we kind of got to have to let this go. It seems as though with a rendering like that, it basically opens up copyright to the point where you kind of don't know what copyright means anymore. So my question for the panel is this: are the courts which were created largely before AI was ever created itself, before we invented AI, are the courts really the best place to hear a case that involves AI? Maybe it's a more modern tool like mediation, tribunals, something of that nature. Because if Google's going to go into a contract with, for example, let's just say a union representing artists, Google's going to draft that contract that largely benefits themselves,
Right.
especially with Google buying more companies and Facebook buying WhatsApp. There seems to be a rush towards who controls more data. So my question is, again, just are the courts really in the best situation to render in an environment that they perhaps may not know? Is something out there that's better? Mediation, tribunals, arbitration. So I was just wondering what everyone's thought was.
Yeah, I really like this question. I think that some people feel like the rise of collective licensing offers some possibility for navigation because you have collective groups that have enormous power and that they can kind of counteract some of the significant power that's wielded by our tech giants. So I do think that that is a possible sort of area to think about. I think the other thing that's really great about your question, though, is like how do we actually resolve tensions, right? Like, is it possible to have a mediation? Other kinds of things. Well, some people feel that it would be great for Congress to get involved and create kind of a compulsory licensing type of frame which allows for some remuneration for creators and also allows for the continued sort of unraveling of the creativity that we see in the Gen AI context. I think the chances of that happening are not so great simply because there are so many different kinds of content creators on the web that are whose content is being used to train. So I don't have a huge amount of optimism, but I take your point, and I think you are right, that there should be a sort of imagination of other ways of resolving it. Certainly settlement. I mean, I think the paper is all about sort of the downsides of settlement and the
Yeah.
upsides of settlement, right? And that makes it really tough. Angela, do you want to add in?
No, I think that was good. I think that you, yeah, said you were very insightful on that.
Okay, all right. Thank you so much. Does anyone have any more questions? I'm looking at like hands here. Perhaps maybe we have time for one more question. Anybody? Oh, sorry, Dan.
Yeah, I'll ask a question because I'm curious about just the broader conversation around copyright. I found this to be such an interesting presentation because there's so many different moving parts with regards to where these rulings are at with the AI companies and this training data. But there's a broader conversation around copyright there, which stretches back throughout the 20th century. And the limitations around copyright largely were determined by folks like the Walt Disney Company, and limitations around Mickey Mouse and trying to get money out of superheroes in Mickey Mouse, which are set to expire at some point in this century. And so I wonder if you might reflect on, just as an open-ended question, whether copyright is really something that can serve artists, or if it's really a tool that's more for protecting platforms and licensors, and maybe just in the broader context too of thinking through how challenging it is for artists nowadays to even make a living from their art. So I don't entirely know what the question is, but I just feel like it's such an important broader context to this, that we're existing in this moment of cultural production where so much is coming from these big companies, and there's so little for independent creators, that they often latch on to these concepts of copyright and of NFT to try and reclaim value in the marketplace. And yet these aren't necessarily the tools that were even set up for them in the first place. Any thoughts on that?
So I really love this question because I think what you've hit on, Daniel, is part of the reason for why NFTs have been so deeply embraced by creators. It's because it actually allows them to go beyond some of the limitations of copyright law. So, for example, like the resale right limitations do not exist. You can embed royalty payments every time an NFT is successively sold, which is different than in sort of the real world. So there are lots of different ways in which you can kind of supersede the existing limitations of the Copyright Act. But I think that as long as we um, are governed by the Copyright Act, and if we believe that the Copyright Act is a really good representation of both public and private values, right? Meaning public value in access to resources and content, and private values in terms of remuneration to the creator. I think people feel like copyright law hits a pretty good balance. I do worry that NFTs allow for this kind of foreclosure of those kinds of limiting doctrines within copyright law, and that paradigm is setting up an interesting set of potentials in the Gen AI context. But I totally agree with you. I mean, I understand completely why NFTs were so attractive for artists at the beginning. I think it's also understandable why they would be in the opposite direction, equally horrified by what Gen AI is able to do.
Yeah, and I think that to what Professor Katya said about optimism of the function of copyright law, I do think like if you think about the original creation of copyright law, it didn't have these companies and publishers in mind. It did have the individual creators in mind, right? Like even the Constitution, Article 1, Section 8, Clause 8, which is what the Copyright Act comes from, is really about protecting individual creators and incentivizing them to create for the benefit of society. And yeah, so I don't know. It just kind of, you just need to, I think there is some optimism that is necessary that um, the aims of copyright haven't been fully lost or like co-opted by these companies that are kind of using it to their own advantage.
Right. Okay. Thank you so much. Yes, definitely. We need a lot of optimism these days. Perhaps maybe before I end this, perhaps just maybe like some final words from Professor Katyal and Angela. Where do you think would be the next? What do you think is the next um, like what's the next step in terms of like where this like lawsuits are going? What do you think I mean, I know predicting the future is very difficult, but where do you think should our attention be in terms of like legal interventions, given that we're we're lawyers? So.
I think in terms of legal interventions, I do think that the collective rights angle is a
Okay.
really important one. The collective licensing angle is really important. I think, making sure that there's a lot of discussion about the impact of these very large settlements. Like I think what Anthropic did, is both admirable and really challenging, right?
Okay.
Because it
Yeah.
set the tone for all future. Um, you know, settlements to go forward, and many smaller many smaller kind of AI companies simply do not have the resources. So I think that having conversations about that is a really important sort of thing to think about, right? That we can have a world where private ordering continues to sort of unfold as it will, because you can't prevent settlements, obviously.
Right. Right.
But keeping in mind the discussion about how slowly over time they do facilitate a kind of locking up of these raw materials that I think are essential for creativity.
Okay. Angela?
Yeah, I think it'll be really interesting to see what happens in the future. I wonder if there will be like almost like a race between these private ordering forms, right, and the courts. But I think in those kinds of races, the courts usually don't win those. They're just, they're too overworked and the process of litigation is just too slow. So there may just be like a very long-term tension between private ordering and the courts, and we'll just have to see like how that plays out.
Okay, all right, great. So thank you so much for your presentation. Thank you both, and thanks to everybody in the audience today for being with us. We learned a lot from this presentation. Join us again next week for our final SRI presentation seminar with Semra CV. But for today, enjoy the rest of your week. Thank you so much, Professor Katyal. Bye.